It's 7:07, November 5th. I want to call the Accessory Unit Study Group meeting to order. Welcome to everybody. We had a nice break, but a lot of information and a lot of communication with some of our representatives and peer communities has transpired over the last couple of weeks, which I think has been very beneficial. I'd like to start with a review of our minutes. We had the October 16th meeting minutes. Where are they? We have the 16th minutes here. Right. I'm trying to find mine. I have my print here. Okay. So there were changes, a couple of changes here. There's a typo on the first line, which you've picked up, I believe. I think we wanted to add in under the background information overview. We had added a note on the research on the 1941 provision in the bylaw, and I just wanted to enter that Mr. Cook noted that there was no case law on this issue. I might change issue to read subject. Let's see. The other item was the clarification on the second page on the first paragraph. We were talking about the study group then began to discuss unintended consequences and wondered if a proliferation of accessory dwelling units or two-family units, and we were clear to make a distinction between accessory dwelling units and two-family units, and I thought we wanted to have that sentence reflect that. So we entered in here a use distinct from ADUs. And then, let's see, in that same paragraph, a little further down, we had on the sentence of Ms. Marwell asked the group if they felt it would be easier to keep the residential, we added residential character of the neighborhoods. Those were all the comments that I had. Are there other comments that?
I called in earlier. There were a couple of typos
Okay.
that I found.
Otherwise, we couldn't.
I had one addition, a clarification really. In the second to last paragraph near the top, it says, Ms. Wentworth explained that a house can be converted to a two-family dwelling in all residential districts from business A or B currently. I thought we should add those pre-1941 houses. So a house built prior to 1941 can be converted to a two-family dwelling in all residential districts. That's an important difference. The second to last paragraph, second sentence, starting with Ms. Wentworth. So Ms. Wentworth explained that a house, I would say, built prior to 1941 can be converted to a two-family dwelling in all residential districts. Yeah. And business A it will be currently.
Is this a discussion to vote on what was said? Or
Yeah,
what is actually the case?
What the discussion was on the at that meeting, the October 16th meeting.
I looked at the meeting on the HCAN. I have a slightly different view of that, but not what was said, but what the effect of the bylaw is in the face of today's legal realities. But if you want to vote on the minutes as to what you said at the time, we can discuss it later. That's fine.
I think, Paul, we have that on our summary outline list. That's one of the items on that list that we were going to discuss. So why don't we discuss it then, and then we could separate out the minutes, the review of the minutes.
Are you ready for a motion?
I'm ready for motion on the October
I would move,
16th?
Acceptance of the minutes as altered.
With second?
Those in favor? Any opposed? Thank you. Let's go to the October 22nd minutes. Should be, there's a second page there, yeah. And are there any comments on these minutes?
Again, I picked up a couple of
Typos?
corrected.
Okay.
One, in the, maybe a third of the way down, first page, third of the way down, the the long paragraph, where it says, the sentence beginning, the group discussed, continues, Mr. Freeman noted that no matter where the ADU was located, if the approval mechanism was a special permit, then the residential character issue could be reviewed at the time of permitting the addition of the word issue, changing than to them.
I just did a small typo, there's a capital T in the last, I think you got that one already.
I called in and talked about the typos also. I made the comment, it's helpful to have minutes like these, I think, for an issue like this, so that people can refer to them. It's we've covered a lot of ground in the meetings, and the minutes are thorough, and thank you.
I was thinking that, I think the minutes are very helpful, and it's nice to go back to check on a certain point in the discussion as we're going through some of these other issues to see where the group was, in these meetings. We've had some very proactive discussions, I think. It's been great. Any other comment from anybody on the October 22nd minutes? A motion? Second? All those in favor? Aye. Thanks. Okay, moving on in our agenda. We've had a number of emails and follow-up questions and discussions and comments with peer communities, which I found very, very beneficial. And in terms of looking at some of those summaries, I'm wondering if it's better to, just as a suggestion, I had put together an outline of topics that we could perhaps discuss. And it really was a distillation of what I saw. We emailed this out on October 29th, and it was just a distillation of some of the comments that we had seen in the meeting, some of the points of discussion, and then some of the other towns, some of the issues that they had incorporated in their bylaws, and then also some responses that I had seen of some of your discussions on the emails with the other towns. And I'm wondering, would it be helpful to use this as kind of a skeleton outline? And when we get to that particular issue, share some of the commentary from the other towns, from your discussions with the other towns as a kind of a way to streamline things a bit. Would that be helpful? I think in the first aspect, which is the 1.0, the purpose and intent. Also, one of the things that I was thinking as I was reviewing this is that we could also perhaps, when we're going through this, list certain items where we have concurrence, where it's just more a statement kind of the record relative to a group agreement on it, and then also maybe separate ones out where there's further discussion or there are a number of issues that we need to look at, or there's commentary that we want to get into the discussion. I think in terms of the purpose and intent, at our last two meetings, we established that there definitely was a need, and the characteristics of that need everything from the demographics, the aging of the population, providing flexibility of housing options. I think it was key that we support a single-family use. In the next two or three, I think there's a need to respond to the multi-family, multi-generational aspects of as lifestyles are evolving and changing. And I think that one of the keys that I came on in looking at a number of our comments in the notes, and also some feedback from other communities, is the issue of the relationship and the occupancy, familial relationship versus a non-family or a related situation or support for that. And I'm wondering, many of our comments, some people thought that it would be best to just keep it in a familiar related basis rather than opening it up to non-related occupancy. And I'm just wondering, what do people think about that?
I think that's some feedback from the town of Dedham regarding that. And this is actually the planner's experience in a previous town. And he said that when you get to, if you don't relate it to family, and it could be in those situations as well, but when you open it, you need to be prepared to receive a lot of demonstrations of needs and why and this and that. If you keep it to a family definition, it's easier perhaps to think about what is a real need, but if you open it up to other types of situations, when the owner applies and demonstrates the need, it can open it up to, he called it like a parade of horrors, and the zoning board can be in the position of trying to determine, well, is yours a need? And but it's yours. And so he said it's not a great situation.
So it's an issue of unintended consequence.
Yeah.
What's the experience with respect to the permit? When somebody applies for a permit, how does the ZBA in Dedham treat that if it's outside of the family?
The person needs to demonstrate the need, and then they make a judgment call. And that, I think, was his point, was that you want to leave as little up to a judgment call as possible.
I'm just not understanding. In other words, is the proposed, or is the actual rule in Dedham that you've got it if it's family, and if you want to go beyond family, you have to demonstrate need?
It was unrestricted. So, yes, and so they get prepared. This actually isn't Dedham, this is from his previous town. And Dedham, he said he hasn't had one since he's been there, which has been 4 years. But he was saying that yes, they went into a whole lot of discussions about what is a real need and what isn't.
So the default that if it's family, it's allowed?
I actually don't think so. I think that if it was family, you still had that situation, but it was easier to determine.
This is John Mason.
No, that's Concord. This is actually Richard McCarthy in the town of Dedham. Let me see if I can find the nightmare to police. Sorry. Get ready for sob stories.
Mm-hmm.
But what I'm saying is, get ready if what happens, if it's limited to families, if it's unlimited. So if it's unrestricted.
So it's not limited, yeah.
So in other words, the problem would arise if it's unrestricted and there's a requirement to demonstrate certain things.
I guess so, yeah.
So would that mean that the potential bylaw would have, one of the criteria would be that the applicant has to have a need for the unit?
Yeah, and I think in a way I was thinking of the previous conversation which I had with Concord, which they have an unrestricted bylaw or ADU bylaw and occupancy requirement, and they found that it was better for them. They have income producing properties. What was good about that was the banks it was easier to police. So we were looking for enforcement measures. And for them that was easier to police because when the property changed hands, the bank would always go back to the town and ask about the special permit. In this case, they had 3-year rollover. They had a tick file, and every year some houses would come up and they would have to investigate. He said at times they were actually sitting outside of homes checking to see if they were really being used for the use that they were supposed to be used for. And he said it was a nightmare to police. But, so, we were talking about do we want restricted or unrestricted. The unrestricted was easier because they could get bank involved when the property changed hands to police. The restricted was easier in terms of having people really doing what they thought they were doing. Let me see if I said that right. Restricted was easier. Oh, for the need. Yeah, I guess that's the best way to say it. So, anyway, so that was just sort of.
Some of the towns, for example, I think it's Milton, and I talked to a number, I'm trying to keep them all straight. I think it was Milton, basically, their concern was that they have locations and districts for multifamily, and a multifamily permit goes in those districts. So they've restricted their accessory units essentially to a familial relationship because this is a special category, and that other multifamily gets covered in another category. What was interesting is that the concern is that it's the evolution of the permit, where if it starts, let's say, with an unrelated, does it progress to a multifamily kind of as things progress? Now, there's a certain level of accountability that happens if every 3 years the special permit has to be renewed, or, I mean, there are vehicles or mechanisms, but the concern was how do they prevent that? Now, the other thing I also saw is that if the use or the accessory dwelling unit use changed or was not in conformance, then it lapsed. There was also a reversibility in that, too, where if it was no longer an accessory unit, they had to convert the house back to a single family. And some towns are following that. It's what I see as a more kind of conservative path, and other towns it's less conservative in that respect. But in terms of managing the downside risk, I think when I see people who are looking at this in a way that's based on need, let's say, which is a lot of the situations we've heard described, where someone comes in and they have an adult child or relationship that are siblings that want to come in and live in the house and they're related, that's one thing. I guess the concern with how this is worded is that there are the people who would not be doing this for those reasons. They would be doing this more for an investment or a speculative kind of a situation. For example, when you see some of the houses advertised, and I've seen some recently, they're advertised as multifamily, or there's an apartment in the house, and I know the house, I know it's only a single family, but they say it's apartment eligible, or I forget what the wording is, but I'm looking at, in terms of how we scope this, yes, it's to allow the need, but then we also have to protect against someone who's not going to necessarily have that same motive on this.
I think we can really bog down in this discussion. Of the 13 towns we've compared, most of them have unrestricted covenants in the bylaw, and I'm tending toward that. And I'm remembering at the last meeting when Tim White was here from Affordable Housing, I think I'm correct, those of you who were here, correct me if I'm wrong, please, that he made quite a clear statement about the difficulty of defining just what family relationships work and the kind of confusion that can arise from it. I worked with in this, getting in touch with the other planners with Weston and Westwood, and if I may just, this came from Weston. Betsy Ware, who's a longtime urban planner, just began saying there have been countless discussions on accessory apartments, and goes on to say the tracking of blood family relatives / family, what is a family today, is an administrative nightmare for the zoning department enforcement officer. I have not and will not advocate having a restriction stating only family, quote, unquote, should be living in the accessory units. My guess is that it would not stand up in court And from a practical perspective, it's the same impact. So, I mean, it's a,
Yeah, I think in terms of response to that, what I've seen is the counterpoint in terms of protections, instead of, let's say, having it being restrictive in terms of relationship. Also, I've seen the approach taken where you restrict, say, no more than 3 persons, no more than 1 bedroom. Maybe the dimensional aspect is a better way to address these issues and not necessarily a personal relationship.
Clearly more objective, exactly.
suggested that it was the owner occupancy and that was the determinant, the strongest determinant factor in the whole thing. They were both talking about unrestricted occupancy.
I talked to the planner there, and she said that in 1989, the town hired a consultant to write the bylaw, and at that time, they felt it would be very difficult to define family. And they also felt that the need to offer more affordable housing units, those are the 2 reasons they went with unrestricted and not family.
And Gary, I talked to someone in Norwell, which was one of the few family ones that says senior, 60 or over, and family. And the fellow who had worked there for several years now had not had anyone come forward for a special permit. And I said, well, how do you feel about this if someone came forward? And from what I see on the sheet, it has to be family. And he said, I would totally be against that. I would allow anybody for a good reason to go for a special permit. So even although the sheet in front of me says family, he said in his position that he would find that untenable and would prefer that we know that Norwell would be unrestricted.
It seems that part of the justification that has been presented is that in fact there's a need for families to be able to take care of direct relatives. If that's not the case, then we're really talking about creating apartments for anybody. I think there has to be some limitation as to who can occupy the secondary unit.
I actually have a question about that. I got a couple of phone calls, and we bought a house on South Street that had an apartment in it back in 1982, and we had, when we applied for a mortgage and all that kind of thing, it was called a legal apartment because some were not legal. And I remember going to Michael Fish at the library to look back at who had lived there. It had 2 sets of utilities, but there were always 2, because supposedly at the time we were told that if 2 years went by and you did not have a tenant in it, you lose that opportunity to collect the rent. And for a while we had tenants in it, and for a while we had my mother-in-law in it, then we had tenants in it. But I have a feeling now, reading these bylaws in Hingham, that I've missed the boat in the past 20 or 30 years, that that's no longer true. Anyone with a house before 1941 can simply come down, even if he's never had a legal apartment, and ask for one.
I believe that's true.
So that's changed since
That-
1982.
That's an opinion that's been stated. Whether or not it's accurate, I think needs to be challenged, because that's inconsistent with how we've interpreted the bylaw in the past.
Because we thought we were buying a house with a legal apartment that had always. We thought, we were told we were buying a house with a legal apartment because there had never been a 2-year period when 2 sets of utility bills hadn't gone out and that kind of thing. But when I read this now, and I think we had talked one time, Emily, about that new house that went out, and before that, it was replacing a house built before 1941, so they had a given right.
Well, so I think what you purchased is called a pre-existing non-conforming two-family, so that 2-family use has been in existence since before we adopted our zoning bylaw. Since 1955, we've not allowed the construction of a 2-family by right. We have only permitted a single family constructed prior to 1941
to be altered or converted into a two-family upon approval by the zoning board. So they can come and seek permission to change their single family if it was constructed prior to 1941 and it has 6 rooms. Yeah. it's
So
not
notification goes out to abutters and there's a discussion. Okay. I just wasn't sure how it worked.
I think there's also one distinction too that I'd like to talk about is that a two-family is all independent utilities and independent space. An accessory dwelling unit basically, in my understanding, would have shared utilities. In other words, the primary residence would have the single bank of utilities, and those utilities would feed the accessory unit. But that would be one distinction between accessory and two-family. So I think it's two different areas. Yes, there is the multifamily and
Understand,
the
so that
precedent, yeah.
really anybody in town, but all of Main Street built before 1941, they have a legal right at any point to come down and say, this is what we would like to do. And there would be an
apply.
open hearing. Okay.
And I think the basis for that is that those buildings were prior to the adoption of the current, of the initial zoning bylaw in 1941.
And they used to be owner-occupied as well.
I don't think they do.
This could fit in affordable housing, in a way better than an ADU. If you're talking about providing affordable housing, these homes could be converted from 1 to 2, and it doesn't have the limitations of the owner occupancy and something like that. I don't know if the ADU is the best way to do that.
In terms of what we were trying to do in terms of our charge, I thought we were making a distinction between accessory dwelling units and two families. The two families and multifamily would be discussed under another review, but we would focus on this for now. But I do see, there are some gaps here, what happens from 1941 to now. There's a whole host of issues there too.
And I have a question that people have asked me in the meantime, that with Back River going in, a lot of those condos have, now I've never gone really down and counted how many appliances they have in the kitchen, but don't some of them really have a secondary kitchen on the garden level so that if adult children come to visit for a week, they're not coming upstairs? How does all that fit into? They shouldn't?
I don't think we have a provision in
They
the
don't-
bylaw for any of that on a legal or conforming basis.
And these are, we're talking about single-family neighborhoods,
Yes.
single-family homes.
So
Not
Back
condos.
River does not have, when those were built, or they're being built now, I've seen a couple what I call a kitchen on a garden level, but maybe they don't have stoves. I wasn't interested at the time to see what they had. But they don't,
In terms of, I haven't visited any of them, or seen them, because I haven't visited them. On the other hand, I don't think we have a vehicle within our current bylaw that would allow that on a legal conforming basis.
okay,
That's my
okay.
understanding. So,
A lot of where that could come into play is if it was a patio level and they were entertaining on that level, and then they would have sink, small stove, they would have it rather than going upstairs to the functioning kitchen kind of thing. That does happen sometimes, but,
So some of them do really have a,
well, I've not been in ones that have, but I'm just saying, in general, that happens in other homes, that you might have that kind of a setup for purposes of entertaining outside, but it just makes it more convenient than going to the main kitchen. But it's not really
Sure.
another kitchen, wholesale kind of thing. It's just,
One issue. I have a very different view of that bylaw. But before I start spouting off, I would like you to just take us through it as you understand it. Feel free to speak your mind.
It's something that's been in the bylaw since 1941. So we adopted zoning, we allowed two families to be constructed by right, And we also allowed single families existing as of the date of adoption of the bylaw to be altered or converted to two families by right. In 1955, things were firmed up a little bit. We eliminated the two-family construction by right and left the alteration and conversion of a single family to a two-family existing as of the date of adoption of the bylaw, so 1941, upon approval by the zoning board, and at some point or another that approval morphed into a special permit process. We've heard recently that the 1941 requirement may violate the uniformity provisions of the Zoning Act because we're treating properties in the same zoning district that in all ways are equal, different just because of the date of their construction.
State statute, correct?
It's a state statute, yeah.
So that would supersede any local bylaw, correct?
Yes,
Yes.
I believe so, but I'm not an
So
attorney.
the 1941 bylaw really is a very, very weak and probably unsustainable exercise of local power.
I think also, though, that's an interpretation.
There's case law that speaks to it,
Well, I
with
wasn't,
all due respect.
in the, looking at the chapter 40, statute, there also is a provision, I'd have to refer back to the actual text, but there is I think there's an interpretation that supports the issue that, the Uniformity Act doesn't apply universally, and I think that my sense is before we would concur to change something, I think we'd need to see some case law on it rather than just changing it. Although I do think, and we've brought it up in terms of, and we've seen in other towns, this under eligibility, would one, in addressing this gap between 41 and now, and also dealing with the issue of accessory units, would you say that you'd make a restriction that the accessory unit couldn't be put in a house that's less than 10 years old or less than a certain time frame? The reason other towns have done that is because it prevents a speculative development on new properties. It requires that they be existing properties, and they've done it for, I think, for good reason. It's another way of looking at it. Yeah, sure.
We've gone into a different subject. And
Sure.
I was going to ask that we get off of the 1941 zoning bylaw and back to the accessory unit.
Okay.
It's different, and we're going to have to be very careful going forward with it, and the planning board is too, to be sure that the public understands there's a difference between an accessory unit and a two-family house. And I'm here to talk about accessory units, not two-family houses.
I concur. And I think,
We have an opportunity to do both. Well, that's true. Not our charge.
so let's continue on our outline. I think that what I understood in terms of clarifying for people the difference is that an accessory unit is in a single-family house. However, it has separate kitchen and bath and bedroom space within the house. That's a two-family, however, is a completely separate unit within the house. The accessory unit is subordinate to the single family. At least that's, I think, when we talked last time, that was our definition.
So if we had an accessory unit in a detached garage, is that two-family or is that accessory?
If in the interpretation I've seen, it can be, but there would not be a maximum of 2 units on the lot. There wouldn't be an accessory unit in the house. It would either be in the house or in the detached
There are communities
house
that
building.
restrict the accessory units to the main dwelling and prohibit accessory buildings from having them, and others that permit them in both.
So in terms of eligibility and applicability, there's also the whole issue of how this is issued, how this is authorized. And I think we talked about special permit. there's three ways of doing this. One is by right, one is by special permit, and the third is with a site plan review by the planning board. There's also which agency in the town would do this. Would it just be the zoning board? Would it be the zoning board in conjunction with the planning board, so that you have use on the zoning board, you have site plan review by the planning board? But I think it's the idea of having it, I think we had concurrence on the idea that it would be done by special permit and not by right. And what I would suggest is we add to that, some towns have done this, add to that the site plan review by the planning board. That would deal with the ramifications. The accessory unit is, the use is what happens inside the building, and there would be requirements that the exterior envelope of the building not be altered from a single-family character. But I'm concerned about, the bylaw is really there to protect the abutters. If you had site plan review, that would deal with the exterior ramifications, parking, access, trash, all those things, entrance, that kind of thing. And I didn't know what people might think about that.
I think it's, when, we went through the group of categories that we all seem to be in agreement about: special permit, building permit, occupancy permit, not changing the character of the neighborhood, and I think that's directly relates to the requirement for having a site plan review in the permitting process.
That's actually a special permit criteria, not a site plan review criteria. Those are all issues reviewed under the special permit. So presently, the two-family use is done just by special permit. Yes, right.
Yeah,
Well,
too
no,
bad.
right. And
Okay.
this is, in theory, an accessory dwelling would be a less intensive use of the property. It is primarily single family, and I would say most communities do not do site plan review on a single family use. It's cumbersome.
You can do the site plan as well as,
I would be concerned about that, not that I would oppose it, but I am concerned about what goes on outside of the dwelling. The parking situation, the alteration of the site in order to accommodate more people. I think those things need to be reviewed.
so let's go, but I think to answer that, we should look at what are the issues covered in special permit, and to see if those issues that you just raised are addressed. Because if they are addressed, then we should hear something else why you would also need a site plan review.
The site plan is a tool to be able to review those in a more thorough manner. And so for that reason alone, I would propose that site plan review be a part of a special permit.
Well, let's see what the special permit conditions speak to. We've got the bylaw
We've
there,
got the
Council, right?
bylaw here. Emily, do you wanna-
Perfect.
Section
Section-
one.
Section
F.
section IF,
So
page 5 of the current version of
the first criteria is that the use of the site is in harmony with the general purpose and intent of the bylaw. So that can be our general purposes and intent, or they can be specific purposes and intent of a new section of the bylaw that you have discussed. The B is the proposed use complies with the purposes and standards of the specific sections of the bylaw. That can include parking, et cetera. The specific site is an appropriate location for such use, structure, or condition compatible with the characteristics of the surrounding area. D, the use as developed and operated will create positive impacts or potential adverse impacts will be mitigated. So if a butter comes and speaks, to concerns about it, I'm worried about the view from my property, the zoning board can talk about landscaping. If they're worried about impacts on light and air, the zoning board can talk about those issues. There'll be no nuisance or serious hazards to vehicles or pedestrians. F, adequate and appropriate facilities exist or will be provided for the proper operation of the proposed use. And G, the proposal meets accepted design standards and criteria for the functional design of facilities, structures, stormwater management, and site construction. They, in many ways, mirror some of the items considered under site plan review, perhaps even in a broader way. And I think it gives, the special permit granting authority, whoever that is, plenty of discretion to review a project. But for the most part, I mean, we've found, and we've talked a little bit about this greater issue with the planning board and the zoning board, where we right now require site plan review in conjunction with a special permit A2. And sometimes the boards are looking at very similar things, and to the extent that they're doing that in a joint meeting, it's maybe not cumbersome or redundant. We find oftentimes that it maybe, it's not necessary. We require the site plan review, but there are in fact no changes to the site. And more often than not, with an accessory dwelling unit, that would be the case. It's going to be maybe a rehab of a basement or a small addition to a single-family home that in all other ways would be allowed by right, and isn't something that the planning board would typically look at.
I mean, I just think from experience, I've sat in on a number of joint hearings with Barry and the planning board, and just my sense is we're bringing an arsenal of his committee to look at this. I just think it's overcoming. When they've looked at projects, the value is just tremendous. But I just, given the scope of what's being looked at, it just seems, quite frankly, a waste of your.
So in terms of the relationship, because it's a small site and basis of the bylaw is that not change the character of a single family, that's, we can put in a number of performance criteria that would cover that. And the special permit could then verify compliance.
Does that cover mitigation to abutters and stuff like that, if there has to be landscaping alterations or something like that, or parking, additional parking? Is that in the
We do look at that.
special permit, or is that
Specifically,
site plan?
whether or not there are positive impacts, or if there are adverse impacts, how will they be mitigated? So that's exactly what we look at.
Okay, and that is in the special permit, not in the site plan.
The last time that the planning board looked at site plan review on a residential setting, my memory is that the planning board waived site plan review. It's generally used in the bigger commercial projects, not in the residential setting.
I think every butter is important, so I just don't want to waive it off. Just because it's a small project doesn't mean that abutter or those abutters are less important.
I think what Mr. Fisher is saying is that the special permit has the criteria to protect the interests of those involved.
Yeah, that's why I'm asking. There are a number of planning and zoning folks here. I'm not, so I'd like individual opinions as well, not just, I hear yours. And so what do you think, Dick?
Well, I think that any time that we can put specific language in the bylaw as to what is expected of an applicant, it helps the process both from the applicant's perspective and
Exactly. I agree with that, yeah.
And one of the tools that we have is existing and proposed plans, which clearly demonstrate what is going to be happening and therefore what will not be happening. And to suggest that that isn't necessary in this situation, I'm not ready to say it's absolutely necessary, but I think it's an important thing for us to address, because without it, we could be making a lot of mistakes.
Right. In terms of the unique aspects of this bylaw and the enforceability, the process of authorization and enforceability, characteristics of the special permit requirements, we would have, for example, an expiration requirement. We have owner occupancy. We have building permit is subject to the special permit. I'm just putting these out for example. There's a renewable basis like every 3 years. The special permit doesn't travel with the owner. Exactly. So in other words, on those specific criteria, all of which are special permit criteria, this bylaw would articulate all of those as differentiated from special permit general review in terms of the process of the relationship of the house and the land to the abutters is covered here, but the specifics on the program, if that's the right word, we would have to specifically articulate in terms of what's included in the special permit criteria,
Right.
so that one couldn't say that if it's not included, it's thereby inference excluded.
Right, like you did for the bed and breakfast, you had a separate section that said, you want a bed and breakfast, you have to follow all of these rules, and you need these blanket approvals. So you have the special permit criteria, but you also have the supplemental conditions. So if that was what the study group wanted, that would be, you'd create a new section, and you'd link it back to the permit. And you'd
Okay.
have belt and suspenders.
Okay.
And we do require plans, the special permit, so if there wasn't a site plan requirement, still a plot plan showing the parking and the site and the alteration of the foundation would be reviewed by the zoning board. They do that regularly.
And I think your example of the bed and breakfast, that's exactly right. That's exactly right.
Okay.
And it would need Board of Health.
Yes, yes.
Excuse me.
Sure.
There was something, I think, Laura, you turned up in your conversation. It had to do with recording the special permit with the registry. And I'm not familiar with doing something like this, but the intention, I believe, was to be certain that upon sale, that they're doing title searches and all of that, that there was evidence of a special permit on this property that should be addressed before the property closes, so somebody doesn't get in under the radar. So I don't know whether
That was from the town of Concord. They came up with an ADU bylaw in the 1960s. It was proposed by the League of Women Voters in response to seniors struggling with rising taxes and who were traveling many months of the year they were away. And so these were specifically for either income, and they had to demonstrate this need actually, either an income need to maintain, to keep one of the big houses because they didn't want them all to be changed or turned over, and maintenance when they were gone. So they were income producing properties, and because of that, the banks and insurance companies had different requirements. So when those properties went to sell, the bank would come back to town hall, and that would trigger town hall to check the special permit. There's more to this. And the interesting thing about that, since the 1960s, Concord has only 80 units. That has been steady for the last 20 years because the financial incentive, if you aren't somebody who has a need for maintenance or income, it's more expensive to finance it and it's more expensive to insure it. So there's actually a financial incentive to convert the house back to a single family. And so they find that for every new one that they permit now, an older house is being converted back. So I thought that was kind of interesting. So that was good because they had the enforcement was pretty good, and it hasn't taken off and become a crazy control thing.
In Concord's experience and discussions with them, I'm just wondering about the scenario where a house is for sale, and basically the ability to secure the mortgage is based upon the primary income and also perhaps support income from an accessory unit. Is that something that banks take into consideration on an accessory versus a multifamily? In your experience, Eileen, have you seen that?
In a multifamily, they will take into consideration 75% of the income unit as far as helping to qualify. I don't know about an accessory unit, but ironically enough, in Cohasset, they only have one ADU, and it's 2,500 units in the town. And in speaking to Bob Egan, the head of the building department, I asked him why they only had one. And he gave a couple of reasons. They have a liberal guest house provision, which allows separate dwelling units for intermittent use by family and friends without remuneration. And then secondly, an in-law or au pair is allowed, and I think this is what you were talking about, Mark, with a deed restriction for family members, et cetera, et cetera. It cannot be a rental. In other words, it can be a newer house similar to the one on Abington Street. And when it's approved, they actually put the deed restriction in so that it's separate from a two-family, in other words. There's a distinction, and you folks that are attorneys know better than I don't know what you do after to, get rid of that, because as far as I know, it's not easy. Once you have a deed restriction, it's there. And the other interesting thing with Cohasset, they have many illegal apartments, and they thought when they did the ADU that they would get a lot of people applying to make those illegal apartments legal, and they didn't. They only have that one. And the reason they think, Bob thinks it didn't happen, is because the process was too cumbersome. Just as easy for the people to just keep it the way it is and, not say anything about it.
Concord issue. According to your notes, is it unrestricted in Concord? And they tried to make it restricted?
Yes, at one point they tried, thank you for reminding that, they did try to make it, they tried to use an affidavit so that it would be policed by the owners. They tried to have them file an affidavit. The proper terminology for doing that. And they found that after 10 years, it was rampantly abused. People were not, they would do it initially for whatever the purpose was, and then they had no way of following up on it. So then they tried again to create a bylaw that would be restricted. And they tried 3 years in a row at town meeting, and it was defeated every time. So,
Did Mr. Minty say why it was defeated?
he didn't say why, but maybe because people felt like they were getting what they needed under the other bylaw. Well, I mean, to me, that seems very different in income producing, because I think, Eileen, you did something last year about, again, insurance and financing and stuff like that. That is different from what we're looking to do here. So their example, they kind of have the enforcement mechanism down pretty well, but I don't think that's the need that we're trying to address. So it's interesting information, but I'm not sure if it's actually all that helpful. When they tried to do something similar to us, it failed by affidavit and it failed at town meeting.
So my point in bringing it up, and we need to keep it going, but is that I wonder if there would be a provision in the special permit that we grant to require an instrument be recorded at the registry, indicating that the permit was in place, and that it clearly stating that it would expire upon be null and void at the property transfer. It's just a means of enforceability or ensuring enforceability, but I don't know whether it's even legal or what it. So
I like the idea because when one does a property transfer, there's the Title V review.
Right.
And a Title V review requires an inspection of the property, and it seems to me that that's something that's already in existence. So couldn't this be, couldn't the two basically be the same? And the trick for it is the sale or the request to close, I guess.
We have deed notices on the types of systems that are underground also, so that the people that buy into that home know that that particular system needs more attention, needs a contract, and has to be registered with the town. And they work very well, either through the bank attorney or even realtors have certainly helped us out in making sure that the buyer is aware of what they're getting themselves into.
And what that would also protect in terms of, let's say, the areas of the town that are on septic, what that would protect is the bedroom count and the surcharge of that particular ecosystem.
Well, that's one thing I think we need to address as far as what comes first. Obviously, when you're applying for the special permit, I think some of this other work needs to be accomplished. Having the people come into the health department and let us know what you have now, presently, what you're going to do, and then look at the files and see where the system falls into place, and then make a decision that yes, you can, or no, you can't, which also takes away some of the time that the zoning or the planning board may have to put into it ahead of that.
Yeah, the first stop.
Exactly. I'm not that I want it, but it makes sense.
Right, no, it makes sense.
But when we do have regulations now that say, before you apply for something, you should have X, Y, and Z, and it's not always, it needs to be very clear. We do sometimes get in applications, and if this is going to be one of those where there's not flexibility, that's it. I think the bylaw needs to be very clear. Because otherwise, we have a tendency to work with applicants and try to help them get their material together.
If the transition of the ownership is, let's say the house is in a trust, and the primary owner of the single family owns, I'm assuming, at least 50% of the property to be the primary owner, and you go through a transition because of a death in the family or because of a transition within the family, that transition isn't really a sale, so you wouldn't have a trigger relative to the inspection on the Title V. I mean, it's basically, initially was created by a special permit. I'm just wondering how that works in terms of the accountability, transition without a formal sale. How does that work? And how does, I mean, one way to do it is to say we have a 3-year renewal, so you have an automatic frequency where you have to check it.
Yep, you do that with condominiums.
Right now.
Right now, for Title V inspectors, you're on an inspection program every 3 years, which covers any sale of any of those units.
What if they're a town sewer?
Well, that's another story. There really isn't anything that.
So there's no trigger for that. They're out of that picture. So then would, to be have a universal plan or policy, would it be then better just to do the 3-year renewable?
Well, it's 1, 3, or 5, or 10. I mean, it's different years.
Well, I was thinking, since let's say it's not a condominium, but since the process in the town is 3-year on the condominiums, would it make sense to do the same thing on this, or to do a separate review? I mean, it's...
Is the check-in to just demonstrate that the same person still owns the property? I mean, is it maybe as simple as just filing an affidavit with the building department that the same owner still lives there, or if the property's sold, that the next owner would like to maintain that improvement as a single family? So there's, I mean, a lot of the other communities, it looked like it expired upon resale unless within a 30-day window, the next owner filed with the town requesting that they would be the owner occupant and would be maintaining the unit.
I was thinking that the process would, on 3-year frequency, would verify 2 things. One, that there was no change from the original special permit, so it's more of an accountability. And then secondly, we pick up if there was a change in a reasonable amount of time. If it went to the sale of the house, it would go 40 years.
Right, it's just a more intensive review than we require for other residential uses. So, it would be a new review process. I think we'd have to think out the logistics and then really understand the purpose of the review. So it would be reopening a hearing and inviting the public back. It wouldn't be a check to see if the impacts of the use have changed. It's simply, is it still owner occupied? Right.
I saw it kind of like a registration.
Yeah.
Where it's a renewal to confirm that the accountability is in place. It's not, wouldn't be a hearing or something that would be intrusive. Maybe you do an affidavit, I don't know, but.
Going back to our first meeting, Mary, you were talking about sending out a form with special permits up to 3 years, and the homeowner gets a form to fill out and resubmit. And
Well, like a license renewal.
sure, yeah, exactly.
We can certainly set up an automated mechanism. I think that what's important for us to be clear about is what information we're gathering, what metrics are we working it against, and we just want to be sure that we're fair and think about the paperwork burden and the impact on the owner. If there's how are we going to do this and just do it consistently and fairly? A lot of times the owner files an affidavit and just certifies. I worked in one community where when it was issued, the owner filed an affidavit and just certified that they understood the requirements and they would comply with them. That was it. We didn't go back and check. We typically would, when the property transferred, the real estate agent would come in and say, oh, great, I found a two-family, and we would find out about it. And that's when, it wasn't the most efficient way, but that's when we would contact the new owner and rectify it. So if there's a middle ground between that, right?
Repercussions if somebody fails to file their affidavit or whatever we're requiring. Does the permit lapse and they're required to go back through the public hearing process at that point?
Basically, a note went out saying, it's expired and to refile it. It wasn't necessarily a call for, because it was an honest mistake, it wasn't a call for a hearing. However, on the other hand, if it's not filed because there's a change, then there might be a review process of that. One of the things I was thinking is that, let's say you have a large house, and a scenario could be where you have a primary owner, they have 50% of the ownership, they live in the primary part of the house, but the size of the accessory unit can change over time. You might not add another kitchen, you might not add another bath, but you might add a number of bedrooms within that house, include more in the accessory unit than what was, and it could be on an incremental basis. And I think it's a realistic scenario. On an incremental basis, you could have a change, and that change would affect more than just the house. Would have ramifications past the house, and it would be nice to have a check every 3 years or so. I don't know if that's the right frequency, where the owner basically, it just encourages people to be upfront and say, okay, it's still here.
With sending out something in the mail, we wouldn't, that scenario you described, we wouldn't know that because we're not physically entering the property. So, we're asking, it's an honor system kind of thing, so I'm not sure that that's the right way.
Could you do it with an affidavit? I don't like the idea of being intrusive.
Isn't the accessory unit subordinate to the main house definition?
It is by definition.
So why would we want to encourage it to grow, to swallow up the main house?
We wouldn't. I'm just saying that if someone changed their use of the house, it might.
I mean,
Right.
I see the accessory unit is potentially something that might not be long-lasting. It might be a young family that has an au pair, and then the children are in school, they don't need it anymore. And my favorite new word from last week, granny flat. So granny is there, she needs it for a couple of years, and then she goes off to a nursing home. They don't need it anymore. Or maybe they're grandparents, and they're living there together, and then they decide to go to Linden Ponds. So it's not something that's going to go on forever. Now, I know that there are vehicles with, because we've run into them with conservation, where you have to put a bond down, like $5,000 or something, that you have a lot of money at stake. And I'm just thinking outside the box here. You're the attorneys. Someone comes in for a special permit, and they say, I want this for 3 years. And you say, fine, no complaining, this is going to be great. But 3 years from now, you have to come and check with us. And if you're dissolving it, we give you your $3,000 back. It's kept in an escrow account. You don't earn any interest on it. But there's then some motivation on your part to go back and say, I'm dissolving this. I'm not having this anymore. I don't want it. I don't need it. And I want my money back. Because otherwise, there might not be any reason. Granny might not go off to Linden Ponds, and you're going to keep it going because you kind of like the idea, or the next person might like it.
In terms of this is one of those consequences of not having the occupants related. So if the occupants are unrelated and the use of that accessory unit changes where it's no longer needed, let's say it was a relative, but the physical commitment's been made to put the kitchen and the bathroom in the house and have the bedrooms committed, so the owner is going to want to probably use that space. And so,
what about that scenario where the elderly ladies live together and one used the income from the other to continue to live at the house? I don't see that as threatening.
I don't either. I'm just thinking.
But maybe every 3 years you have, if you had some money down, you'd have to say, every 3 years I'm coming, things are just the same, she's still there, I'm still there, and you keep on going. But at some point, if it changes, then you have the motivation to say, come see my house, kitchen's gone, we're not using it anymore, she's moved out, and I want my money back. And so it's kind of a win-win, that the town knows it's no longer an accessory unit, and you're getting what you put up with. It's just an idea.
So the issue is really managing change.
Because conservation does it.
They do. If something was going to change, there would be building permits, as Emily stated. If the unit was going to change, the walls were going to change, kitchens or bathrooms were going in or out, the building commissioner would see those permits, and they'd check the files, and I'm sure he would say, oh, there's an accessory unit there. Wait, what's going on? And so, I mean, there is a standard of review to manage the incremental change, presuming people pull permits, and we have to presume that people pull permits.
I think we're getting bogged down in a lot of details. I think the real question that should be answered first is, are we providing for a need of specific homeowners, or are we providing for a housing need in the community? Because what we're discussing now is all related to a specific homeowner and how you revert what action the town may take. And it may not be what you want to do.
Right. The two towns, Cohasset and Situate, clearly did it for both reasons. Both.
Right.
It wasn't just one or the other, it was both.
That covers everybody.
So if we did it,
Did you poll the group to see who's had the generational relationships in their home? Just curious.
I don't know if we did. Did we do it at the initial meeting? It would be interesting to see. Current.
I've lived with an elderly granduncle within the home. I've lived with an adult child and her husband and my two grandchildren. So that's a motivator for me for this discussion. I think it can suit both ends of the spectrum, to be honest with you. Whether it's the young family starting out or somebody winding down in the autumn or fall years of their lives, or winter years, rather.
And also, I think in terms of, a lot of us are in the sandwich generation where we have elderly parents and we have adult children. And we have given the current demographics, a lot of us have adult children living at home, going to school and whatever, but still spending a lot of time at home. And/or I haven't recently had an elderly relative living at home, and I think the thing that I see is it would be really nice to have separate facilities because your lifestyles are different in terms of the time of day and your work cycle and that, to me, that would make or break. So if you did that in a related situation, it works out fine, and then it transitions to an unrelated situation, then it addresses what Situate and Cohasset are looking at, which is essentially, if it's there to support the single-family use of the house, and it's separate kitchen, separate bath, then that could be a financial help to the person who is owning the house. Given if it's shared utilities, it always stays in that control. Whereas if it's, then the distinction is made, you don't separate utilities and you don't separate the unit from being a subordinate unit. It's, the intent is still realized.
I do have to add, just hearing people talk about having basically grandparents and the grandchildren living in the same house, and you know why grandparents and grandchildren have such a special relationship, is that they share a common enemy.
There is something to that, Counsel. She's not watching, though. So.
Maybe we should change what we call these.
One of the things we haven't discussed too much is, again, I'll use Cohasset and Situate. Cohasset only allows the ADU within the main building. There's no auxiliary structure. Whereas Situate does allow two structures on one lot. And that is where they, they didn't really, it wasn't indicated to me that there was a lot of issue about it, except that is, they're going back now to town meeting this year to amend the size of the second structure, because that was the one unintended consequence.
So in other words, a unit in an outbuilding, or a barn, for example, the size of the unit was greater than they anticipated that they were going to get, so they put a restriction on the size of that in the outbuilding.
Right. They sometimes went to 1,200 or 1,500 square feet. And then what they're going back to town meeting with is 40% of the main structure, or 900 square feet, whichever is less.
So in the towns that seemed that we looked at, it seemed to me the majority did not allow the accessory unit in the detached structure, but an argument was made in either Weston, I think it was Weston, an argument was made that if you allow the unit in the accessory structure, you have a situation where now both buildings are maintained and preserved equally.
That is exactly right. And that was, again, Ms. Ware, Betsy Ware, whose home is in Newburyport, where that same situation arose with a lot of old houses without buildings, and there was a kind of preservationist concern, and she suggested that that would be something that would be of interest to Hingham with its historic architecture, because it's an incentive to preserve the outbuildings that could fall into disrepair.
Now, would we,
Could you say, what if the existing building doesn't meet those parameters? Could you say, or the size of the existing building? You know, say the barn is twice as big as his house, or something, you know what I mean? So that he doesn't have to shave it down or something like that. You know what I mean? Exactly.
one might say one bedroom, certain square footage size, whether it's a prescriptive size or a percentage of the floor plan, so that it's proportional. And then one could say that then you don't alter at all the architecture of the barn as seen from the street. So again, it's a single family with the barn, and then there's, there are ways of dealing with the entries in the.
Yeah. Your favorite Lexington has two different restrictions, whether it's within the primary dwelling or if it's detached. It's actually, well, I don't remember the details.
Detached structure brought up when I was looking at how different towns looked at it, is it seemed to me that it was always an existing building. It was never a new building. In other words, it wasn't the basis of a new permit for a new building. The rationale was that it was to preserve an existing building, which implied that it had been in place for a certain number of years.
Is that the rationale behind the 10-year?
And that was the rationale behind the 10 years, so that it doesn't become speculative endeavor, or encourage that it's really done to address the specific use.
Again,
Or need, I should say.
I'm not going to object to that strenuously, but I don't see the harm of allowing it with somebody who buys a lot of land that's suitable to build a house with an ADU in it. But not two-family, remember, it's an ADU. And why we would restrict that, or somebody buys an existing house and demolishes it. And the existing house was large enough, and the lot is large enough to accept one, but we would prohibit them from doing that. So again, I don't want to stumble over something that's it's like the site plan review. We don't need to layer on things that aren't necessary. And the recording of a deed, I brought those things up. They complicate the process, and I just wonder if putting a limitation and has to be an existing house. Some of the towns are 2 years. Many of them are 10. I understand that, but in my reading, I haven't understood exactly why.
What if somebody found a lot of land and had a need, whether it was a disability, family member? Sometimes new construction is easier to do than retrofitting an older house, and then some people are compelled to do that. And so,
Handicap access is a lot easier to do.
oh, definitely.
One of the things that we looked at several years ago when we had the allowing professional use in an outbuilding, part of that discussion was the preservation aspect of having a use in the building. It would then thereby be maintained. But the other thing that came up in that is I thought the suggestion was made that the building had to be attached to the primary building.
Being altered.
So it would have to be attached. So in the accessory unit discussion, does that make sense that the building be attached, or is that an artificial? What I'm trying to get a sense of.
Yeah, but I think one of the motivators that drove us on that whole discussion was that people were attaching these historic bonds to these houses and compromising the integrity of the property. So why would you want to do that here?
I was just
don't think we
thinking in
should.
terms of in the discussion of allowing new buildings, the outbuilding. I'm trying to address the concern of doing this on a speculative basis. That would be purely for income rather than to meet a need.
I understand that if we're talking in the context of two families or multiple dwelling housing, I don't get it when we're as a speculator going to put a spec house with an accessory unit in. I don't see it.
Well,
But
the Board of Health is in play again. I'll use Situate, only one septic per lot. So that if you have a 3-bedroom house and you only have a 4-bedroom septic, your auxiliary unit only can have 1 bedroom. So that's a clear, distinction, 1 septic per lot, no matter how big the lot is.
Can somebody explain to me, so you have accessory dwelling units with one utility bill, and they may or may not be for income producing. You may just have a family member living there for other reasons, or if the need changes, then you may have a rental unit. Does that make any difference to the town in terms of how it's permitted or how we check up on it? The difference only to the owner, who I believe has financial issues when it's an income-producing property. Then you have different banking and different insurance needs. If it's an ADU and you have somebody living there, accessory use or a family use, they don't have those issues. So I guess what I'm asking is, what does it mean to the town in terms of procedure, process, permitting, stuff like that? Is there any difference if they're being used for non-income producing purposes or income producing purposes? Do we know that?
There's none. I mean, so
There's none.
Unless you write something into the bylaw, I don't see.
So it's just easy to flip between the two from our purposes, for all intents and purposes, the owner may not tell the bank or the insurance company, but that's their problem if there's a problem.
If it's an income-producing relationship, then the property is worth more, so there's an assessment issue.
Also insurance coverage.
And an insurance issue.
If you're renting, you've got to have rental insurance. I have an office over my garage. I have a binder, independent of my homeowners, just because I don't want there to be any kind of problem. And, it costs a little more, for sure. I don't know if that would be true if it became my bedroom and kitchen.
I sleep in the office sometimes.
Sometimes, yeah.
But yeah. I was just going to say, but answering your question, I don't think from the town's perspective there's any difference. Yeah.
Because you can have multi-generational families living even now, as long as there's only one kitchen, can be 9 people in the house. but, you know, there's no, it's one electric meter. That's how it was in our house.
Would there be a need to look at the prices of properties that have this conversion? And if so, what are the consequences? Is the property value greater, or is it less valuable? Are we getting into an entirely new area?
When I looked at the meetings that were preceding me tonight, the takeaway that I was getting was that it was very important for the look and the feel in the residential setting not to be compromised. And I think that that's perfectly appropriate. And I guess what we're trying to do is figure out how do we accomplish that.
To your point, this is before whether the assessment, the town assessment, would go up or down in with a property with an ADU in it. And I asked Rick Nolan, the assessor, that question. I CC'd you and the two of you, I think, and I think I'm correct. I don't have that email reply, and I think maybe when we go forward with the planning board or something, I might recommend inviting him to be a part of a discussion to address it more clearly. But I think I understood the difference between an assessment and an appraisal. The assessment is the town instrument, the official instrument for setting the tax on. And the appraisal is what Eileen does, and I used to do in real estate, and we're looking at the property value. That has no impact on the assessment. When I believe I'm correct, and help me with this, that Rick was saying that an assessment is really related to the land and improvements to the land. And that if there is an improvement internally to the house, that it might not necessarily impact the tax rate. So I think there was some misinformation, and I may be misinterpreting what he said, but I think it's important because it did come up in the first meeting. You put this in, your taxes are going to go up. It's a disincentive. But that may not, in fact, be the case. We're not qualified to comment on it, but Mr. Nolan certainly.
Reading distinction too is the value relative to the assessment versus the marketability, which is the property value.
Yes.
Even if the assessment goes up, you're getting more value out of the house.
Well, that's
you're using it to a greater value.
We weigh ourselves down on this, but the question does come up.
Right. One of the things that I wanted to do, taking a look at the clock and everything, one of the things I wanted to do, just in terms of talk a little bit about process, we're trying to, in terms of, and we spent a lot of good time talking about a discussion of the parameters. And I think we agreed that we wanted, at our last meeting, we wanted to review parameters and review experiences and distill these experiences with other towns to validate some of the parameters that we would include or not include going forward. And I'm thinking of the next steps and the next meetings. One of the things that we'd like to do as a product of our committee review is to be able to make a recommendation to the planning board as to how we would proceed, and that would be on November 17th, I think it was, November 17th. And
to have something in filed with the town by December 1?
Yeah.
Right, the planning board is voting November 24th as to which bylaw revisions would be sent upstairs to the selectmen. Upstairs by December 1st. So the planning board is going to determine what bylaw changes they're going to send upstairs at their meeting of the 24th. So the thought was that if this committee reported out by November 17th to the planning board.
What are we reporting out? Well, recommend something? I mean,
well, that's the
shouldn't
question.
we put it down in writing?
We originally thought we would put together a list of shared agreements on a series of parameters. And I thought that perhaps could be done in like a skeleton outline, which would be the basis of the bylaw that we could flesh out in terms of language.
But if this goes to advisory committee, which presumably it will, you don't want to be drafting a zoning bylaw, right? Right. No, but you know what I'm talking about. I mean, I think that this will go smoother and the success is more likely if something comes out of this group that the planning board can crunch around and work through, and it'll be further downstream by the time it gets to the additional review processes. I think it's a mistake for this committee not to come up with something.
Well,
to report out. I mean, you've done a lot of good work. Even though I haven't been here, I've watched both meetings, and I can tell there's some work going on here.
I was thinking in terms of an outline list, and one of the thoughts behind developing this list and trying to distill and bring to one sort of summary list the discussions we've had and the issues we've agreed on. There are some areas that we haven't resolved. But I'm just wondering, as a framework, moving forward, would it be wise to distill that, schedule another meeting to get them, I'm trying to think out loud, and I asked Joe for your advice too, in terms of fleshing out a proposed, let's say, bylaw initiative. You review a lot of projects against the bylaw, so you know what they're supposed.
I'm going to stamp my foot.
Okay.
I would like to see us have another meeting. I would like to, before the November 17th meeting, and I would like to see, taken from our discussions, we're now approaching 6 hours of discussions about a series of categories in this issue. And I would like to see a bylaw draft bylaw written that we can look at the next meeting and work it through and perhaps come up with agreement that we pass that document to the planning board for further discussion. I don't know, Paul, is that sort of what you're thinking
I
about?
think we're there, to be honest with you, Gary. I mean, I think you've articulated the issues, and it's really just putting pen to paper. The
Think this
planning staff, I'm sure, going to do a fine job of distilling out what we talked about.
as a set of categories, in terms of using this as kind of a skeletal document to establish the categories.
Well, they're all there. All
Yeah.
of the towns have the same categories. You know, the spreadsheet, that's all the categories.
That's very generic. I'm trying to have this be,
Why not? What's wrong with generic?
well, I think we've established,
Got the size, duration.
so I think we've articulated and summarized that. I was thinking, is there anything in this outline as a series of categories that we would strike? I mean, could we use this as a base of those categories, a basis around which the narrative would be drafted?
Are you referring to your memo?
Yeah, the summary outline.
I think that the issues here I have, I think so, yes.
Like, for example, the 10-year, which is
Yeah,
here.
I had an issue with that.
Whether that
I don't care. I mean, yeah.
It's that kind of thing. What issues would we strike as being not appropriate? Because it seems we've covered most of the items in here as appropriate. Is there stuff in here that
could be written into a draft bylaw, and then we come back in a few days or a week or so and go, you know, chew it over.
See what we'd like.
Let's
do it. Do it, we're here.
What is the process, and what is the calendar for the ultimate adoption of the zoning article? We have a deadline for this committee to make a recommendation to the planning board. How much time does the planning board have, and what license do they have to modify it? And then they submit it to the Board of Selectmen. Can you give me a calendar on all of these events?
I can. The planning board's last meeting before the December 1st deadline to send potential warrant articles upstairs is November 24th. They have to decide at that meeting which articles are going to go upstairs from them. Now, sometimes they're completely fleshed out, draft bylaws, very specific. Other times, although nobody likes to hear the language, they're more of a placeholder. They're a broader bylaw because you can never broaden the language once it's submitted. you can narrow it down. So whether it's a completely finished draft or it's a broader statement that we may make changes to the following sections for the purposes of doing an ADU bylaw, that material goes upstairs by December 1st. The Board of Selectmen then refer it back to the Planning Board. The Planning Board has to open a public hearing. And we will do that in short order, typically within 30 days of when it comes downstairs. The Planning Board then has public hearings, at which point the text has gone over line by line with the Planning Board and the public and modified.
January, February.
The Planning Board would likely do those public hearings starting in mid-January.
So the January 20th cutoff for the warrant.
That's not for bylaw changes.
Okay.
Zoning bylaws have to
Goes
be
right up
upstairs
through.
by
Okay.
December 1st.
So we'd have a framework that we would have, the planning board would vote on and endorse by on the 17th, or the following the 17th.
What you're voting on as a planning board is which warrant articles or potential bylaw
We
changes
wanna-
you're sending upstairs,
Okay.
with the understanding that the language may not be final because you
Right.
will be modifying it during the public hearing process.
So we have a 3-month process then from the time we send it upstairs.
But I want to make sure that we've got a complete answer to your question, because I think it was important. And my understanding is that you asked whether or not what this group does, whether or not it can be changed by the planning board. The answer is yes. And whatever the planning board does prior to December, it can be totally modified subsequently when there are public hearings. So whatever is done at this, among the people, this group is not in no way locked in stone. And as I understand from what you're saying, is that what the planning board can do is say, we want to propose a bylaw that addresses these types of units. And the language doesn't have to be as specific as the exact text. And that it can be, if it's broad, then there's discretion to narrow it down as the hearings progress. If what they sent was a specific bylaw, then that's what, you couldn't broaden it.
You could always narrow it, but you cannot broaden it.
Can't exceed the scope.
So, and I can send you, we had that last year, in fact, we had a broad description of accessory unit potential bylaw, which the planning board ultimately decided not to refer upstairs. And I can email that out to this group so you can see what I'm talking about as far as a broader language. But you're completely correct. Once it goes upstairs, you don't broaden the categories.
So can we send the framework upstairs?
We can refer up whatever you'd like, but Mr. Healy is correct. For this group, you're making a recommendation to the planning board
Right.
about what you think is appropriate. And so I think to the extent that you have strong feelings about that or suggested guidance, we should do our best to draft something and not have someone else try to then decide. There was a lot of work done here. So
Do we want to go through and strike items in the parameters? If you're going to be drafting, if we're going to ask the staff to draft it, should we strike aspects of the parameters so that at least we have a clear direction on the parameters, and then we can move to that draft, and then we can take a look at that draft next time?
I think that's great.
Okay, let's do that. I think the first one I see here is this 10 years, it's the timing, it's the eligibility timing.
Yeah, I also don't think that's lawful under.
You don't, okay.
So that's,
I'm looking at
Page one.
that up on there, yeah. The 1029, 2.0 and the 2.0A3.
I'm also nervous about too, Gary.
the pre-1941.
Yeah,
So we could just take both those out?
I think we shouldn't even talk about that.
Okay. I think we talked about site plan, with a special permit, but not the site plan.
Are you okay with that? I mean, I
Well-
sort of jumped in and I want to make sure that.
I think when I read, as long as when I read the language on the zoning board review, your criteria of review in terms of, I'm most concerned about protecting the exterior impact to the abutters, the ramifications of this use to the abutters. I'm trying to think the best way to do that. I originally thought the site plan review was the best way because that's the way we do it on other projects. On the other hand, given the size and the scale and the criteria you have articulated, it's all internal, then I could say that's fine. But I do think we'd have to, you know, for example, like the bed and breakfast is a good outline. We've got to be really specific.
Yeah, okay.
We can craft the criteria
Yeah.
for the special permit.
Exactly.
That's,
Yeah, I agree.
so let's change that. Let's say that we'll craft the criteria in the special permit. Under B, we could go B.1 that will craft the criteria for the special permit. That would be good. I think the next one, I thought it was important that we specify what the primary ownership is, and there probably should be a minimum. Is it 50? Is it 51%?
Well, typically, it's, the other towns will say minimum of 50%.
Minimum 50 is how they, I mean, it seems.
That's my recollection of it.
Two owners. 50/50.
Right.
No, they're not. It's one owner. So these cannot be condoed.
Right.
It's a single family, so it's one owner, 100%.
No,
And-
it can be single owner, two people.
And so the occupant has to, okay, the person living there has to be at least a joint tenant. Okay, I got what you're saying. Okay.
And then it runs with the land, or not to run with the land. And then the issue was the time frame on the permit, and this is part of the criteria for the special permit. Is it 3 years? Do you think a 3-year rollover is appropriate?
That's just an administrative issue. I mean, do we want to have the staff deal with that? What do you?
Well, the census goes out once a year. So, you know. Yeah, I mean,
I think it's probably a system that's bound to not be followed. So, I mean, it's just, we'll talk to the building commissioner because they do annual recertifications for other uses. We'll see if this is the type of thing that could be.
Since the commission is fundamentally enforcing this,
Can we
I
leave
don't know
it
if we
blank?
said that.
Do you think we need that last sentence?
The other part of all this is,
I mean,
there
that's kind
aren't
of
that many units now. At maximum, what have we all found?
Very few.
I mean, yeah, exactly. It's small clerical.
It's
you
a
know.
small amount of
Yeah.
administrative work, but it would be a way to, it's just a mechanism. It's like renewing your license.
Exactly.
I think it encourages people to be.
Can we leave the term side lease and just put a blank in there and
Yeah. Yeah, we could
discuss
do
it?
that. Yeah.
Emily, do we issue special permits that typically expire?
No.
I've never seen one.
So this would be an odd, if circumstances had changed,
Specify that it terminates upon resale. The unusual factor here is that it requires owner occupancy. So how do they demonstrate that they continue to occupy it? So prior to the sale, if they move out, unless you're providing some sort of notarized letter that other communities have.
So, but this is, just picking up Mary's suggestion on bed and breakfast, that we also owner occupancy as a condition there. What do we do?
What do we require? Question.
And we've got the language here, who's ever drafting it, shall be issued to the owner and is not transferable to a subsequent property, so those conditions are here. So in this bylaw, it says the owner shall file an affidavit with the building commissioner and town clerk on an annual basis in the month of January, stating that the property is the principal residence of the owner and that the owner is in residence at all times.
I think we should change that from the town clerk to the building department, since the town clerk's not, at least for this, we don't have to touch the bed and breakfast section, but,
So if that's how we're handling it, then doing it, I'd rather do 3. I wouldn't do
That's why I was
Yeah.
suggesting 3. It's a
Yeah.
lot less onerous than
Yeah.
every year, but then again, you do
Do
say
it,
the
but just
census is
tracking
every
the
year.
language here, we don't have to invent anything.
No, that's true,
Yeah.
that's true. Let's say, yeah, okay. So you want to change the 1 to 3, I guess, on that.
Yeah.
We'll end up changing the bed and breakfast bylaw when we change this one. Not
No,
tonight.
Well, the other thing is that there's issues.
Okay, so then the item D is, I think the last sentence, the arbitrary issue relative to the ZBA, we could strike that.
Which one's that?
The last sentence on C,
Approval for additional permit arbitrarily, yes, no, zoning board shall be totally arbitrary.
I thought you liked that.
Yeah, exactly.
I wrote that for you.
Full shot to the ZBA.
For you.
Between the two of you guys, I'm just gonna leave right now.
You're amongst friends. Good friends. And I think basically the D,
Yes, you need a building permit.
and then E on the certificate of occupancy.
That's sort of the definition. Yeah.
I know it states the obvious, but I'm just thinking if it's not there, is it by inference, I don't know.
That's what the building commissioner's role is. That's how we do construction now.
Right.
So it kind of goes without saying.
So any use in any occupancy is dependent upon issuance of C of O. So that's typical practice, then I guess you could
Yeah, I don't,
take that out then, if it's covered.
So we did, the whole thing's going on.
E,
Yeah.
It's interesting to me that most all of the towns specify an occupancy permit in the bylaw.
Specified, this language was in all of the towns that I looked at.
So
And I thought thereby there must be a reason for it. It wasn't,
I think it's redundant. I don't think there's a harm in the redundancy, so
Okay.
I would just do whatever.
They're going to have to comply with Board of Health requirements, whether our zoning bylaw says it or not.
yeah.
No accessory dwelling unit permit granted shall take effect sooner than 10 years after final occupancy permits are issued for the property. So this is the.
So this is the issue of, you don't think that's appropriate? I mean, again, it gets.
Problems with that.
It's the same thing.
Equal protection.
Number 2, just written.
Yeah, and this deals specifically, this would prevent the very issue that Mary was raising in terms of, someone has a house built because they have special needs.
Right.
You have to wait 10 years before they.
Well, there's a hardship clause, right?
We did.
And then you can have the parade coming in. We don't want that.
Yeah.
All right.
Yeah, so I would strike that.
All right.
Oh, yeah.
Yeah, they call them variances.
What about G? The first G. You know I like the letter G.
Very good.
Is this lawful, G?
G?
I thought permits ran with the property.
No, you can specify that it terminates, that it's runs to the owner versus if the bylaw provides for it,
Yeah.
then you can authorize it for the
So it is
particular owner.
Yes.
Yeah, isn't this our only trigger really for checking?
Yeah, so I would keep that G, then the second G.
The two Gs are related. I guess the question is whether you want to broaden the second G to allow a lesser process where they could simply notify the town that they'd like to maintain the accessory unit without going through a new public hearing process, because presumably the only factors that's changed is somebody different is living there. Right? It's still owner occupied.
So, and what we've done is, quite frankly, I'd be comfortable if they submit it to the zoning administrator, and if you flag an issue, then there'd be a hearing.
Right, because I think under the G, I was thinking it's an application, it doesn't necessarily require the hearing unless there's something at variance, and then you'd have the hearing.
There's not,
No.
right, but there's no variance here. This is just special permit. So I think if you're going to require an application, they have to have a hearing. So
They have to. Oh.
I think,
We'll look for language from other communities and come up with something
I guess the 10% that was from towns that were more populated than we. Some towns, it's 1% of the housing stock, the housing units.
But that's, and it's impractical, it's acknowledged that that's would be impractical in Westwood. They will revisit it because they're near that cap. Yeah, and they don't want to curtail it. Yeah, it's working. Yeah, it's working.
So no sense to put a cap on it.
Well, I have a question. I'm going to disagree with it ultimately. If you put a cap of 10%, is that telling people that it's appropriate in this community to have 10% of the housing units converted?
It's an interesting signal.
The plan was actually going
I'm not sure we want to send that message. Yeah, so
to just strike it.
I agree.
Now, I guess in terms of general requirements, we make a distinction on the residential districts only. In the overlay district, you'd want it, so you would do it. Is that business A?
That's a question for the board.
Well, in the center, you've got business, but are the houses within the business in the center?
Yes.
There are.
Existing
Well,
non-conforming.
like on Leonard Street, and our Main Street, and Short Street.
And you mentioned the downtown overlay district in this? Because I guess the issue...
On North Street?
Yeah, the North Street, did you mention that in here? The other question that's related, I don't know if it's part of this, but right now when a residence is converted to commercial in the business district, you can't convert it back to residential.
Right.
Am I correct in that? If one wanted to do an accessory unit in a house that's in the downtown business district, could there be a process by which that house could go back to be a residence? Because there are a lot of old big houses that are in the business district. No, but I'm just putting it out there as a thought.
Well, does that
But
part
that-
of
so
the other
that-
bylaw have to apply to this one? So if you convert it from residential to commercial, you can't convert it back. Does that have to apply to this bylaw? You know, if you add an accessory dwelling unit, does the other bylaw say that you can't turn it back into single family?
The other one says you can't convert it back to a residential use. Once it's
But does
converted.
that
changing
even
use.
relate to this, I guess? Is what I'm
Maybe
saying.
it's not.
Maybe it's just
really.
completely
Yeah, I'm
separate.
missing what you're...
I was just trying to include, there are some buildings that don't apply to this, yet it might be appropriate that you could use them with an accessory unit, because they're in the overlay district. The overlay district sets additional criteria over the zoning bylaw, and I'm wondering, this is in some respects like an overlay, because we're not restricting it to certain areas in the town. So as an overlay, would you then index that? Is that something that we should address? Is it?
I think I would defer to Emily and Mary. I don't feel qualified to comment. I don't really, not conversant with what all of the residents A, B, C, and D requires, and I'd just soon defer to somebody who knows.
I don't have a problem with it. I was just thinking that one of the goals of the overlay district downtown was to encourage residential use in the business district. It's not happening to them anywhere near what they want. It seems to me this would give them a provision for the use of increased residential use in the business area. So that's the only reason I brought it up, and whether it's appropriate here or maybe we raise it somewhere else. But
Well, on the flip side, if someone owns a big house and it's in a business A or B district, should they be precluded from having an in-law apartment simply because they're in a business district? And maybe what we can do is look a little closer and see how many properties actually fall into that, but.
There is one down there that it's a big old house and it has a studio, a separate building, and that could be an ADU. And it would not seem right to disallow it.
okay. So Mary will look into that. Okay.
But I think I'm inclined to say it should be in
site came to the zoning board or the planning board, and there was some unique characteristic that made it not appropriate, would not allow it. So
Right.
is there a harm for allowing a broader category of properties?
Yeah, the bigger issue down
Consider-
there would be parking. That would be the issue, is the parking along North Street.
Next item should be, for some reason, my computer's
It's another
out
G.
of control, you know? The, so this was just kind of defining the minimum. I was on, it's I, but it should be B under 3. It was just trying to define the characteristics of the unit, complete separate dwelling unit containing accessory kitchen, bathroom, and means of egress. Do we put the issue in there that it's subordinate to the primary residence? Instead of a complete separate dwelling, complete subordinate separate or something?
I think we should be able to use barns.
Oh,
We
I
should
mean,
use barns. I mean, I
accessory.
don't want to be writing something that collides with that goal.
So except ADUs and outbuildings as well. Should there be a different size characteristic for the ones in the principal residence versus in the barn? I know in Situate they have had, I talked with Laura, the planner, and the reason why they're going back to town meeting is they've had quite a big problem actually with the accessory structures, particularly along the coastal areas. They're really turning into summer houses or second. It's not really an ADU, it's more of like a two-family on a lot. So she did caution me that may have different opportunities with an ADU and an accessory building. And you may want to look at them differently as far as size, but she said they can be problematic if you don't limit it. And it's hard to enforce.
3 persons, 5 to 700 square feet in the outbuilding versus 5 to 800 in the primary residence?
Just to go back one step, Gary, as a committee, how do we feel about having the accessory building be part of this? Or do we feel that we should just deal with one building with the ADU in the building? I mean, as a committee, we never really talked about that one issue independently.
Middle of the road here, and that is that any building barn that exists at the time of the adoption of the article should be eligible. So that people are not building lawful accessory buildings and then converting them.
I'm in favor of accessory buildings being included, whether it's, we use that language or not, but.
But you wouldn't want people building for that specific purpose.
I don't know. Yeah, and it comes back to the no harm, no foul kind of thing. If they've got if they have the minimum lot size and there's a demonstrated need and they comply with the conditions of the special permit, I don't know that
Without going, but it opens us up to, I wouldn't want to have an opinion. But I think it's something that needs to be looked at.
I think if we did it that way, we'd have to go by percentage of either the lot or the original house, because you limiting it by size might have a teeny tiny little outbuilding in a big house, or just different sizes.
On what the accessory unit cannot exceed, and just come to an agreement that way.
Percentage rate, percentage of
That's what I was going on, 1 bedroom and 5 to 700.
Would you agree with?
One bedroom, definitely. I mean, I don't see it as like, oh, we're gonna have a 4-bedroom accessory unit. No,
No,
that's ridiculous.
but to create a structure for the specific purpose of converting it to an
That's where I was going with the existing and had to be closed for 10 years.
That's a harder question for me to answer, to be honest with you.
Yeah, I'm certainly comfortable with Dick's suggestion, but
I just think that if, somebody's got a house where they can't do the accessory unit, or it would compromise the integrity of the house, go to the barn as their option. Not a 2,000 square foot barn. Right? You just have a limitation as to how much of the space that you convert into this accessory unit can be, whether it be within the house itself or within the barn or the garage, whatever.
And going back to Eileen's question, couple of thoughts that I've had all along. I've seen the need on specific situations, you know, people we know who have outbuildings and they want to have an accessory unit, so I see the need. And then I'm thinking of the discussion we had with outbuildings when we were talking about professional uses, and I'm wondering if you do the accessory unit in the house first, and see how that goes, and then you do add the, and I'm just thinking out loud in terms of what is the acceptance level relative to the town at town meeting. How far do you go with a new bylaw? Do you do both now? Do you do one now, the other later? Or if you do both, will it preclude acceptance of the initial? I'm just trying to think of how this is going to be perceived.
At public hearings, and if
No,
there are
I think,
objections.
yeah, you can do that in the public hearing,
Yeah,
sure.
I think my sense is that to the extent town meeting sees discrimination, that you're favoring one type versus another, that's
Okay.
likely to be more controversial and to hurt us rather than comprehensively dealing with it. So for those people who
Right.
the outbuilding works, and for those, you know, we're treating them both.
Right.
fairly.
It gives them an option.
Yeah,
I mean, that was our argument on the accessory, the office space on the accessory units, just to allow people to maximize, the property that they had.
Right. I think we're going.
People agree with us.
One of the things I was thinking about is, it's one thing to have an accessory unit in one building, it's still one building, one lot. It's the idea of two buildings, one lot, two units, one lot, two structures, one lot. And I'm not saying I'm for one or for the other, I'm just trying to think out the.
We're going over ground that we covered earlier in the meeting, and the issue of preservation. And one of the themes of the meetings is we're trying to construct something that is appropriate for this town. And I think we will all recognize that this ancient town has a whole lot of outbuildings in it. And I think to exclude them is a mistake.
The existing outbuildings.
Well, yeah, to your point, sure. Yeah.
well, but if there's an existing outbuilding, and if I was to build a new one,
Right. We're talking about the same 1941 issue.
right, you can't,
Yeah.
you can't tell me, I can't do my building like you would do with yours, because yours is pre-existing. But that would just violate state law.
But you could deny a special permit for a second unit.
Yeah, you could, but you know what? I had a 300-year-old barn on my property that we couldn't use. It just collapsed. And it ended up going to the dump. Sorry, Gary. I would have loved to have preserved that.
Well, why don't we do this? Why don't we say we leave it in, and, it's part of the public hearing? And let's further vet it. See, and take the temperature through the public hearing. So let's do that. I was just bringing up that. Okay. So the issue of the lapse.
What are we on?
We're on letter C, 3C. The issue of the lapse. The conditions of lapse would be no longer owner occupied. That essentially it, no longer owner occupied, and then what happens?
Sometimes it's vacant for a year.
Vacant for a year.
I wouldn't want to do that, because I know, actually, like, my mom will go down to Florida for an extended period. And I just don't want to, I don't see the value.
How are we going to track that? I mean, it's one thing to check an owner.
We actually have people stamp their passports in Hingham Town Hall just to make sure.
You didn't have to go through the checkpoint?
That's right.
Gee, you have to talk to Mike about that.
Enforceable. It really has to be enforceable. We don't want to say something that we're not going to be able to do. That's not fair.
So we should say that you have a lapse, it's no longer owner occupied. And then the condition of reinstating the accessory unit is to a reapplication of the special permit if it lapses. Sounds fair?
You want to do that, or have it go to, what I suggested before, to the zoning administrator, and if there's...
If there's a cause, then have a...
Right.
Yeah, you could do that.
Is that the only reason it would lapse? Would it lapse if something pertaining to the condition of the special permit weren't met?
Well, if they violate the terms of the
Right.
special permit, then...
That's a lapse.
Right, that's not a lapse, that's a revocation. And you have an enforcement order, and there's all sorts of issues there.
VOB.
So that doesn't have to be stated, that's current
Okay.
process.
Correct.
Okay. The next item was maintaining the character. And so I think what I'd probably add to one is principal dwelling and the accessory building. In other words, you'd want to maintain the character of the building and the barn.
Yeah.
Okay.
It's rather subjective, isn't it?
Subjective in terms of the character, or?
No question about that.
Well, I'm thinking that, all right. But if you have,
One curb cut, you could say that it can only have one front door, or any new entryways are on the side or the rear, so we can propose.
I was thinking of where the primary entrance would go on an outbuilding. So in other words, if you have a barn and it looks like a barn from the front and you put a door in the big door, or you change the look at it, it compromises. You could put the door on the side. Sure. Or the rear, just like we would on the house, the accessory unit would, entrance would change the front, kind of thing.
So are we going to define what single-family character is? Oh, no. We're never going to do that.
We'll never get out of here.
We can propose some language for you to whittle down that might help clarify some of that.
Where I see this being somewhat problematic is the area of Pro Point. They have small lots. They have second buildings that you could put an apartment over the garage. They do not need to deal with Title V, so the Board of Health isn't as impacting. So you could see, you know, if you're looking for problems, you could see that's where potentially the density there, you know, it's,
That's in the plan already.
okay, good.
That's happening.
I know.
It's in the play already.
Yeah, exactly. That's when the board did the a stricter Title V, it was to try and prevent that from happening over there. But the thing that happened over there was town sewer. And so that took it right out of play.
The other thing that's happening is the issue of averaging setbacks, and people are aggressively interpreting that. I think that's the best way to describe it. And it's an issue, and so what they're doing is if you have a house that's 10 feet back from the street, and you've got a house that's 6 feet back from the street, and people want to enlarge the house, they're averaging the setback, saying, oh, I have 6, I can go to 8. I mean, if I get 8, I can go back to 6, I get that additional space. I mean, it's the unintended consequence of an aggressive interpretation of, you know, what the bylaw is, and
Although I think in fairness, that's before the ZBA right now,
It
so
is.
we shouldn't really
That's true.
chit-chatting about
that's
it.
true. I didn't realize that it was in front of the ZBA.
I was out of the room, I didn't even know what we were talking about.
Perfect timing, perfect.
Perfect. Timing is everything, Joe, you know what? And then we were, and so the idea was, you know, the independent access egress, having it not compromising the single family, principal dwelling. Plans and elevations,
Yep, I think
verifies what they did.
exactly right.
And then Should there be a relationship between the size of the primary dwelling and the size of the accessory unit? Should we say the primary dwelling has to be 1,500 square feet minimum in order to have an accessory unit, which is 25 to 35% of that size? Does that make sense? Something like would you put a scale or a proportional relationship in that? Or would you do a prescriptive saying that the unit would have to be, let's say, one bedroom, no bigger than 500 square feet or no bigger than 800 square feet? Is it better to do a prescriptive criteria, or is it better to do a performance criteria which deals with the relationship?
Well, there are two-bedroom houses that have been approved in Hingham that have 4,600 square feet of living space. I wouldn't go down the road of bedrooms. I would just go with the square footage.
Square footage. So would you say, I mean, a house that's a fairly decent-sized house, would you say, if we did a percentage of the house and it was 20%, then the accessory unit could be 800 to 900 square feet? If it was 25%, it would be 1,000. So should we do a percentage, or should we do a specific size of square footage for the?
I think I'm leaning toward a percentage and a square footage range, whichever is smaller.
Okay, that makes sense.
Which
They do that?
40% or 900 square feet, whichever is less.
I agree, you need that higher percentage for a
Right.
smaller house.
Okay,
So that's, yeah, I agree.
40%. So we could figure out what the numbers are, but, okay. So you have both covered. I like that. So you have a formula and then you have a max. Okay.
And we're using the same formula for the building.
Outbuilding, yes. So we should add primary dwelling and accessory structure.
And I think the important part there is whichever is less.
Yeah.
Okay, good idea.
Something tells me at 40% rings high, but
I think for smaller houses it works, but Hingham houses would be larger. I might say 25%.
I've seen some small houses.
Yeah, there are small.
Okay.
We're saying whichever is less.
Right.
If it's a giant house, they get a 900
Right.
square foot
Okay, all right,
or
that's cool.
1,000 or
Yeah.
whatever you say.
Yeah.
So I think the important thing is to figure out what's an appropriate square footage.
Right.
I'm not sure about that. I think I like 900 better, or 900 or 1,000 better, but
Then it's always,
not 1,200 and
it's always subordinate if it's 900.
You bet.
If it's an 1,800 square foot accessory unit, it's hardly subordinate, even though
Right.
the house is oversized.
Right.
A cape is about 1,000 square feet. If you think about your traditional
That's right.
cape.
One-story cape.
One story.
Yeah.
A one-story cape and with like 2 bedrooms upstairs, maybe 1,000 square feet.
Yep.
Bradley Woods.
Okay.
Bradley Woods is,
Not with dormers, not just a,
isn't Bradley Woods about 1,000? Maybe
because I had a cape
max
that was 1,000 square
1,200.
Right, so
Yeah.
so the 40% would mean it could be 400,
or 900 square feet,
whichever is smaller.
whichever is smaller.
So it's capped at the 400.
400 feet, which that's pretty small.
It's a small.
well, but it's, and I'm not sure we should ignore the fact that there are some properties in town that aren't going to qualify.
Right. I mean, if you have a 1,200 square foot house, it's going to be impossible to have 2 separate kitchens and 2 separate bathrooms and a single bedroom in that house, in addition to living, dining, and 2 bedrooms of that house. In other words, the size of the primary.
Unless they do an addition. I brought up 1,000 square feet for the conversation point of, is 900 square feet an
Right.
appropriate size for an ADU?
Yeah.
But if you had a cape and you want to do an ADU, it's likely you'd need to do an addition, which if you have the area, you're allowed to.
Well, that's why I said here that 1,500 seemed reasonable, because rather than 1,000. But if you have an addition, you'd have to do it in such a way where it didn't alter the single-family character of the house, right? So that's a tricky deal with.
It's a building addition, someone could do it by right.
Yeah, no, I understand. I'm just saying in terms of the character of it, there'd be some.
Well, if you picture Bradley Woods Cape
Yeah,
with the one-car garage,
right.
and then somebody says, all right, my mother-in-law wants to come, we're going to convert the garage and we're going to put a space
Yes.
over it.
Yes.
And then you could comply with this potentially,
Because it oftentimes-
because you'd make it 1,500 square feet, and then 40% of that could go for the ADU.
What we found on the Hatfield Amendment is that on that type of a house where, let's say, it's existing non-conforming because of the revised setbacks of the house to the side yard or the rear yard setback, you could enclose the corner, because the garages are often offset off the front of the house, so you could enclose, as long as it's within the lot lines. So there's a way to meet the intent and meet this too. All right. Item 5, I think the intent there is to basically, I don't know if that's the best way to word it, but is to have really no more than 2 units on the lot. You can either have a unit in the detached structure or you can have a unit in the house, but you can't have both.
Yeah.
That's where I was trying to go with that.
And that-
Oh, and it
absolutely
says it
right.
that way. but-
That's exactly right.
I don't know if there's a better way to say that, but 7 bedrooms?
Who's been smoking something?
Where did I say 7 bedrooms?
Sorry.
These hairy things. I originally was thinking 2, but I've been hearing it would be better to have it 1.
What is the bedrooms? You're talking about the ADU?
ADU would be 1 bedroom.
Just 1 bedroom.
We don't typically regulate interior space.
No.
If you're saying what the maximum outdoor size
We're
of
doing
it
square footage.
it probably doesn't matter how many bedrooms they put in it. Right?
As long as it's
As long as they
Right,
comply
right,
with
but
Title
that's-
V, but that's
it's already
separate.
That's handled separately.
Right.
We're talking building envelope, each unit uses the space.
Right.
Yeah.
And then we don't care how they configure the interior.
Yeah,
But-
I don't think you have to talk about bedrooms, because somebody might put in one single studio room, 20 by 18, a little kitchenette, and, in a bathroom, and would have no bedroom technically.
I was thinking about more.
Space would still count as a bedroom.
Except the space.
Purposes.
Well,
So-
again, if we're not in the Title V area, it doesn't really matter, but it would technically, I don't know how a studio would come into play, you'd have to.
Well, they call it one bedroom.
Okay.
So maybe I would clarifies it and then strike that.
Well, on B too, I would say it in a different way because it's confusing to me the way it's written.
Okay.
That the maximum number of bedrooms on a single-family lot with the accessory unit, I have shall comply with the requirements of Title V and the Hingham supplementary, Board of Health supplementary rules and regs.
That's a
The way
better,
it's written, it says permitted septic system. To me, what that means is they have to comply with the system that's already in the ground.
okay, good point. Okay, so let's change that to read, how would you like
I
that to
would
read?
just say that the accessory unit shall comply with the requirements of Title V and the Hingham Board of Health supplementary rules and regulations.
Gary, can we go back to 6?
Sure.
Need a clarification as to what we're saying here.
It just means that you can't rent out rooms within the ADU. So rooms, not that you can't rent the entire unit, but you couldn't, within that unit, rent a bedroom to a kid, right?
Right, so in other words, you
We
wouldn't
talked about
have,
this in an
No
earlier meeting.
Airbnb?
Yeah.
So in
No
other words,
Airbnb,
so
yeah.
you can rent out the ADU, but the ADU resident cannot rent.
No subletting.
or in the main house, if you have boarders in the main house, that is actually 2 units, and then the accessory would be a third, so we only have 2. I was trying to say it would be a maximum of 2, and so you either can have the lodgers, or you can have the ADU, but you can't have both in the primary, because now you have 3. And that's multifamily.
But, so the boarders and lodgers concept is, as I'm understanding, the ADU is not renting itself out to boarders because it itself is a rental.
But also, in the main house, you couldn't rent out rooms in the main house, plus have a separate ADU, because now you have 3 dwelling units.
Correct.
On the same lot, rather than 2. That's what I was trying to say.
Okay.
I don't know if it,
Okay.
Then do you want to say, because this regulation is about the ADUs, so if there's no borders or lodgers applies to the main structure, do you need to specify that? Which we could certainly put some language in for you to find.
I'm just saying, if you don't specify it, will people say it's not controlled, and thereby nobody says you can't do it, so I can do it?
Well, it's not stated it's prohibited, right? Isn't that how the code's typically interpreted?
Yes, that is how the code is typically interpreted.
I was just trying to err on specificity. I understand the issue of, right, it already being covered in intent, but
Yeah, so let's, I think Mary's idea of putting the language in and then we'll look at it when it comes to it.
all right.
I think we all.
So we'll review language.
Yeah.
Okay. Fine.
I
Okay.
promise.
Compliance with all applicable codes and bylaws required at the time of the issuance of the special permit. Is that fair? Compliance required with all deed restrictions on the property?
I don't know. I mean, there's oftentimes can be private deed restrictions on a property that the town has no authority to enforce. I don't know that, what kind of deed restrictions
So
are you
why don't we,
thinking of?
yeah, I
was
think you're talking about town deed restrictions.
That's correct.
So you're exactly right with respect to private ones, but to the
Yeah.
extent the town,
We should say municipal or town.
yeah.
I was thinking if you had a drainage easement, for example, and you had an additional parking space required because of the ADU, you'd have to respect, it's just an example, it couldn't encroach upon that easement.
You can't compromise it.
Probably catch that at your review of the plot plan that should show the easement. So the zoning board would catch that.
Right, but I agree, we should not be in the business of enforcing private.
No, it's just,
restrictions.
the intention
Right,
was
right,
was-
exactly.
I should, is it? All utilities, extensions of utilities serving the principal single-family dwelling.
What does that mean?
Well, what it would mean is that instead of having, typically if you have separate meters, it's a two-family house. If you have single meters, it's a subordinate unit to the primary residence.
Everything feeds off the single meter.
I
Right.
don't think we care
Right.
usually, right? So, I mean, what makes it subordinate is its size. And, I mean, we usually, zoning doesn't necessarily mandate how the utilities get to it.
From just an electrical standpoint, if it's something's being built, and I don't want to require the electrician to have to wire it over to a meter that may or may not be appropriate. And second, if it's going to be rented, there's a value to having it separately metered.
There is, but this showed up in the majority of the bylaws that I looked at. I didn't,
I like that
I saw very
idea.
few that didn't have this.
You like it?
I like the single meter. I think
I saw it in one or two, but I don't remember seeing it in the majority.
There's a whole section of the housing code that we enforce on metering and cross metering. And it deals with, if you've got one meter, you can't bill out separately to the tenant. If you want to have separate meters, then you have to have certain devices and wiring and plumbing fixtures. If you want to bill out water or sewer bills, all that has to be separated, very specific in the housing code, which we enforce.
And I was thinking that what you basically have in an ADU is that it comes with utilities included.
I mean, I
That would
think
be the simplest
the
way.
principal motivator here is families making accommodations for family members. But at the same time, recognizing that there may be some kind of income component at some point, but that's not the primary drive
Reason we're doing this.
behind this undertaking. And I think that will be an easier, I shouldn't say easier, but a more persuasive argument to make before the town when we're going for
I would agree.
town meeting approval.
It strikes me that whatever economic arrangement someone wants to make, if I'm bringing in the au pair who's going to be blasting their air conditioner, I'm going to say, you're paying for it. And I'm not sure why the zoning board, or why, not the zoning board, why the town wants to regulate how I'm dealing with this other, knowing that I have a choice. But I'd like to preserve that choice. And I just don't see the benefit to the town of taking that choice away from me.
I think that the presence of the single meter encourages the interrelationship between the parties to a stronger degree. I mean, even with the au pair relationship, it's removed from the family members, so to speak, but it's still a strong one as opposed to an arm's length transaction with a stranger, where the idea of a meter may be more appropriate.
To me, the separate meeting.
What motivates me on this whole thing is older parents, young families starting out. See that as kind of the prime driver of the effort here.
These are residential neighborhoods. I don't think we want to really encourage rental populations within those.
If it's within the envelope of the main house, having just one set of utilities is logical and viable. But if you have a second building, you have a barn, and like we're talking about, we're going to preserve the barn. So now you're going to bring in utilities. You're not going to put radiators that are in the main house in that new structure. You're going to put new kind of heating, wiring, and all that. So maybe we differentiate. Maybe if it's a ADU within the main building, it's the contiguous utilities. If it's a separate building, then it's allowed to put in separate utilities. Because it isn't really feasible to, do you think?
Typically, an outbuilding, if you're using the barn for the barn, and not as a residential unit on a single-family house, you would typically have a primary meter and a primary panel, and then you'd have a secondary sub-panel out in the barn for the power, and then from that panel, you'd have separate heating system if you had it heated, or separate plumbing. But you'd still have everything from the utility perspective. It's single metering. It's sub-panels, but single metering. And I think it goes to Paul's point of the primary residence.
That's what I have.
Everything here supporting the primary residence. If it's separate, it's really a two-family.
I have, the house that I live in was originally a one-family, then it was a two-family. It's still the presence of two water meters. We eliminated the second meter, put in single service. The garage that we have has a box in it, but it's all going to the main panel inside the house.
And what did you do in the barn?
Well, I have an office over the garage.
Is that wired into the main house?
Yes.
The heat and everything?
Yep.
What kind of heat did you?
I have gas.
That's good.
It'd be interesting to know what other folks do, because depending on the proximity to the house or not, that may or may not be viable.
I'm just saying what I did. It made sense to, I never thought to do it any other way, to be honest with you.
The intent is really to require that there's one meter. It's appropriate that it's housed in here, but otherwise, I'd encourage you to weed out any overlapping jurisdictions to the extent that you can, so that the building and zoning staff are not making sure, yes, there's one meter in addition to the building department, in addition to the Board of Health. So, if they already require compliance with Board of Health regulations, maybe it's covered and there's already separate requirements for provision of utilities in whatever manner. It sounds like you guys wouldn't mandate that it be one service. So if that's your intent, then it does need to be here, and we'll be the ones checking it.
I see this coming up actually in a rental situation, more than family members.
Yeah.
Right.
And what happens is one complains to me, and then I get involved, and he's charging me for this, and I'm paying that, and back and forth we go. I don't see that happening in a family situation.
I mean, typically, the water is one service and the septic is one service and or the sewer is one service. And that's typically paid by the primary homeowner. And so what you're really talking about is an electrical. You could put a sub panel in with a sub meter in, but it's off the primary meter and it's one utility. You can do that. I mean, it's still the primary feed coming in is the single family. I always see separate as two family. That's what sort of sets the,
Right, that's why we got rid of our 2 meters. The house was started as a one family, and when we sell it, it'll be a one family.
okay, so we want to continue. Parking. Typically, I saw one space minimum for the accessory and two for the one space maximum for the accessory and two for the principal, but, you know, that might not work, for example, downtown, it might, you know, I don't know, if you can set a prescriptive criteria. Should the parking be off-site for all of the, sorry, on-site for all the occupants?
The existing residents theoretically will already have parking.
The existing building.
Right, the principal residence should theoretically already have parking. So would the bylaw just identify requirements for the new dwelling unit?
Makes sense.
Down in the shipyard, we expect it.
But that's not single family.
Yeah, it is.
The single family
That's
resident,
single units, but it's not zone single.
We dealt with the realities of the living arrangements.
but the town doesn't allow overnight parking off-site for any residential
Well, we did. We
neighborhood.
did it.
What if we just did something like one additional parking space for the dwelling unit,
Makes
right?
sense.
And then that's,
Okay.
that's
Yeah,
it.
we don't have to deal with the principal.
So in other words, are we saying one in addition to the two?
Yes.
Why wouldn't you allow the accessory unit to share one of the two?
Share, you could, but the bylaws that I saw clarification where you couldn't piggyback the cars, you had to have independent access.
Yeah, but you don't want.
Meaning you couldn't park in front of somebody, you couldn't, yeah, no tandem.
That's the big problem.
We don't require that.
Not here, but
It's really the issue to have it all the,
You don't want them on the
capacity
street.
offsite. You don't want them on the street, that's,
That's it. Right, but that's different from saying that we need additional parking because you could share and then they're not on the street. I'm just thinking of the elderly family where basically one person is no longer driving and then the reason the other person's here is actually to do the driving.
if you require one parking space, they always have the ability to go to the planning board for a parking determination. They can get a special permit A3 if they need a waiver of that. So there is a relief mechanism that's not burdensome. It's not variance that they'd have to seek. It is going to a different board, but, or you could embed it in this, and you could provide the special permit granting authority with the waiver provision.
Space for every car that's registered in the-
Yeah, exactly.
One space per ADU. But it's fairly typical.
Yeah, I know that, I think where Gary got the information is that you know, the 13 towns that we look at, almost all of them specify one, a couple of them say adequate.
Just coterminous
You know, I worked in one place that said all parking must be on the site, and when they applied, they had to show us their plot plan, and they had to demonstrate their driveway was big enough to accommodate, you know, the principal residence, and if there was going to be 2 cars with the ADU, we did in-laws. They proved it, they showed the driveway. And maybe that's the way to handle it as part of the special permit.
I mean, I'm just thinking of my mom who I don't want to drive and I want somebody else.
this
to
would
make
give
sure
her
take
an
it.
incentive to drive.
No, but you're requiring her to have that spot
No,
for a
you're
car
right.
she's
No,
not
you're
going to use. That's
Yeah,
why
you're right. So why don't we just say the one additional space, or one space?
They don't have to use the space.
All parking must be on site.
I think we're talking about all parking has to be on site.
Yeah.
That's the concept.
Define parking. Are you talking about constructing a paved parking area with access to it? Or is it less formal?
With a curb stop.
You want 2 driveways onto one property?
We'll let
No.
Mary do that.
Some of the towns are quite specific.
They are specific.
A hard surface.
That to me is important,
I agree.
because if
it's
the
not,
law
we're gonna end up on the
changes,
street.
that's where it's going to kick in with the perception issue.
Yeah.
So let's put our thinking caps on that one.
So
Seems innocuous, but not really.
So why don't we develop some language?
Because that's gonna be the most, you're right, it's gonna be what's most visible.
The outside impact
What's
is gonna be the
different about
cars.
Exactly.
The additional cars, where people are gonna say, oh, that's different.
An additional driveway in the Hersey house.
So we'll develop some language on that? Okay,
And by the way, maybe the answer is exactly what Emily said, we leave this, what you've got, and then if there's an issue, they just come in and seek relief. That would be the simplest way.
4 was an attempt to deal with the existing, in other words, have this be addressing an existing need in an existing building, but we talked about that and whether we need to do that or not.
I think we could X those out.
A is out.
What about minimum lot size? Yeah, for it to have an accessory unit in a detached accessory structure, should there be a minimum lot size? If it's existing, the lot is the existing lot and the building coverage on the lot is existing, but if it's new, should we have a minimum lot size?
We have a minimum lot size for an auxiliary structure.
No.
Right. So the setbacks. So if we have a detached building in the back of a lot, all of the setbacks are gonna apply for both structures, so that will determine a minimum lot size.
Right.
I think
Unless you get
the health is also gonna have a play in this too, because of our nitrogen loading requirement.
Okay.
So you're talking a 4-bedroom house, you're up into 50,000 square foot lot.
So so what I'm hearing is we're not looking for an additional minimum lot size above what we currently have.
Right.
Okay.
We want to maintain the minimum per the current zoning and Board of Health requirements. Maybe we say it that way, that the minimum lot size
But
is
isn't
that
that
obvious.
implicit?
Well, that's,
It's obvious.
Conversion of pre-existing non-conforming structures, is that?
Right,
Okay.
without precluding. I was just trying to, B, address
Yeah.
structures that happen after the adoption of the
Right.
bylaw. And do we say something about, do we have, should we say something about that for newer structures that are built after the bylaw?
I think if, you can't build the structure unless it complies with the setbacks, so there's no additional
Right, okay.
setbacks that you need.
So that's redundant, okay. And then the other one was, so the other 2 will go away too.
Yeah.
And then the appearance, I was trying to get to the essential character for the purpose with it, for which it was constructed. So if it's a carriage barn, it would want to look like a carriage barn rather than a small house. You
Yep.
know, so it doesn't look like 2 primary residences on the
Exactly.
same lot. It's the house and the subordinate building, which is, and then scale, thinking of the relationship to the adjacent houses. And this is, that's almost a new, that's almost a new building versus an existing, unless alterations to the existing building should be within the scale of the existing building.
Is that subjective?
Probably is.
Because historically, the historic districts look at it anyway.
I mean, if this is an existing building, it
So, I
probably
mean,
is
there
under
may
the-
already be a
Right.
control for
Yeah.
altering the
Mhm.
appearance of the structures.
So by scale, I was thinking of proportion and dimension, which I was thinking was less subjective than aesthetic. It's the size, it's kind of a dimensional control, it's the bulk, the massing, and the size. Which to me wasn't as subjective as, you know, what it looks like, or the character, or that kind of stuff.
Although that's equally important.
I think it's important, because that's what people, the neighbors are gonna see that.
It's got to fit
Gotta
in
fit in.
seamlessly.
That's where I was, we could say that.
Sit in seamlessly, no.
Is that too subjective?
I mean, but what we look at, what the zoning board looks at right now under the special permits is compatibility with the characteristics of the surrounding area.
That's part of your
That's
criteria.
That's exactly what we do.
Right there.
Right,
There it is, yeah. That's not subjective as written.
totally subjective.
So we could write it to what you just said.
Yeah,
Put what you said. Oh, it's right there.
That's the special permit criteria.
All right, so we'll put, okay. And then the other item was, the last one was screening, and in other words, prevent any spill of sound or light, or, you know, if you have lights on the building, or you have, in other words.
Oh, yeah, I mean, Todd is all over that,
Right,
actually,
right.
so, yeah, that's exactly what.
I'm thinking lighting and sound.
Yeah.
Okay. And then there's accessibility in ADA, which is, that's usually a interpretive and performance.
That's really a building code issue. Yeah.
So instead of special permit granting, it would be the building.
So that,
But you
Yeah.
look at that too?
no, we don't, and
You
I don't think we don't.
So if an application comes in and it's not accessible, do you have a requirement that the submission be accessible?
I mean, if the homeowner has a need for it to be accessible, they will do that, and the building
But that's
commissioner
not
will
something the
review
zoning
it.
board would look at,
Okay.
and,
All right.
yeah, we would defer to the building commissioners to whether or not whatever's being built is appropriate from a accessibility standpoint.
Okay, that's fine. The other item I was looking at here, and I didn't know the answers to 5 and 6, we have legal non-conforming dwellings, which are, you know, and we have the issue of buildings that have been, they're non-conforming but not legal. And so there's an issue of amnesty program or something like that. Is that something that is controversial and outside our scope at this time?
That's a 2015 undertaking, I think.
Okay, that's fine. That's why I didn't write anything about it. I couldn't figure out what to write.
Yeah, that's a tough one.
Took a nap and had a stroke or something. I don't think you would address, do we address who can live in this? Is it going to be familial, or is it going to be unrestricted?
I thought we said that it was going to be, we were going to look at dimensional and size and those issues. But what did we say? Because I know we talked about both.
We talked about it. Before we got into the point-by-point build up, but it's not specifically in this, and so
That's hard to regulate.
well, I think so, and I think it should be unrestricted. That's my
I think the dimensions, the single metering, that serves to kind of
right.
contain it to a familial relationship.
And you're not alone in that feeling
That's a good point.
with other planners.
Yeah. I mean, it lends itself to the informality between a parent and a child, or a child and a parent, or grumpy old grandfather.
Well, again, using Situate, 8,000 households, 75 units currently, and 75% of those 75 units are familial, even though they're unrestricted. It's
Right. That's
just
the practical
usage,
implication.
usage.
And I think Tim Hoyt, last 2 weeks ago,
Right.
said essentially the same thing.
Right.
We're asking for trouble if we try to define it.
That seems to be what I think what most of all of these communities have come up with. You can't define family, and even more so now. And it'll just evolve to, I don't know what the unintended consequences could be if these communities who have had it for 20 years or better haven't found any issues with it.
Yeah, does anybody in all of there's some people here who aren't here who picked towns. The 2 planners I talked to indicated no problems. But that's, no, not that they're aware of.
It sounds to me that the physical constraints that would be put on these units would encourage a familiar use of this than a non-familiar use. Is it supportive of that? So maybe that gets around the issue of
That's the
regulating
reality.
the reality of it.
You even have to touch on that third rail about, who's a family member, and
That's true.
what household member. I mean, it is defined broadly these days in the eyes of the law.
Okay.
Question from the audience.
Yes. Judy.
I just had a thought on the
Probably should, Judy, could you come to the mic, please, so that folks at home can hear it?
Can you raise your right hand?
You family
Yeah, we
member?
know.
I duly swear that I'm a family member.
And we know who you are.
Judy Kelly, 9 Providence Lane. And my one thought was the pattern of bedrooms, where it's at one bedroom maximum. And I was thinking of a situation where children were bringing in their elderly parents, and maybe one of them had like a long-term disability, something there, and they may wish to have 2 bedrooms, one for the, other one for the father, under certain circumstances, so that you limit it as 1 bedroom. You might want to put 2 in as an option.
I thought where we came out is that we were regulating the square footage
Right.
and not the number of bedrooms.
Oh, so you're not including
But,
bedrooms?
but
Okay,
the Board of Health will wind up looking at that issue.
okay, I didn't realize you were
Right,
taking that out. Thank you.
Thanks, Judy.
How we doing?
I think we're at the end of our, at least the outline is.
If we go past 10, you buy them.
Good job, everyone.
I know,
Great
I,
job. This is great. We made some progress tonight. I love it.
Unless there's anything that we
have
need
an
to add, have we left anything out? Is there anything we need to add, or are people comfortable with where we are?
Good job, Gary.
It sounds like the next meeting, we're actually going to look at
Yes.
a bylaw that incorporates this.
Yes.
And
Well, if we have to make a recommendation to the planning board on the 17th, today is the 5th. Is there a date next week that we could meet? Thinking it's Thursday, Wednesday or Thursday? No, Wednesday we have a meeting, can't do Wednesday.
I have a meeting Wednesday too.
When-
Yes,
uh-huh. Could we do, is Thursday a possibility?
Yeah, I won't be here. We don't have a meeting this week, but I am
You don't?
heading off to Louisiana, so by all means, don't let me hold you up.
We can email you the draft, you can review it on the trip. And
Sure.
I mean, the other option would be the following Monday, the 17th?
It is.
you have a planning board meeting at 7. If you chose to, you can meet before that, but that's your. I know to write the draft is probably not realistic to say before Thursday, because Tuesday's a holiday. We have a meeting Wednesday.
Right.
So if you wanted to get together before the planning board meeting, we could email you the draft, I think, and take comments back. Hopefully it'd just be some minor revisions, and maybe 1 or 2 things to really.
But it'd be nice to have the group be able to kind of discuss stuff with the draft.
Although I think we have consensus. I got the feeling we have consensus as to what we want to see.
Yeah.
Anybody disagree?
I think the primary issues, we're pretty much in agreement.
Okay. All right. So
Agree.
we don't need a meeting, we want to distribute the draft, let's say Thursday or Friday, and then we can look at it over the weekend, and then if there are comments,
Can you
could then incorporate
We'll
them
have to
Monday.
talk about it tomorrow, and
just do your best and flash it out to all of us?
we
and
certainly.
We'll take a look and
Great.
So then you will present it on the 17th as that fearless chair to the.
Step to the planning board.
He's the chair of the planning board, so really, it might be good if someone else reported out. I mean,
Do
I
it.
guess you could, but we're.
do you want to do it? Good.
Well, Gary's going to be acting as chair of the planning board, so it just may be awkward.
To be both the
Right.
presider and the proponent.
Right. It's not a conflict, is it?
So were we going to meet for 30 minutes before, just to get our ducks in a row, or are we?
I wouldn't mind meeting before the planning board. If we
Yeah,
could,
maybe
could we meet at
45
6?
minutes or something.
Could we meet at 6:15, we meet at
Yeah.
7, would that be possible? 6:15 on Monday, 17th? I'd have to look at it. 6:50. I'd like to look at it with the group, just to make sure we're all on the same page,
Makes sense, yeah.
you know? Or if there's things that,
Sounds good. 6:15,
17th.
17.
Yeah, great. Thanks, everybody, for all your input. It's been
I
great.
gotta say, this was my first meeting with you guys, and it's incredible how much work has been put in.